We are back in court July 10th for the court's continued hearing on Karen Reed's motion to compel Colin Albert's deposition. Remember that the court already issued part of a ruling on this, and the part of the ruling was, I'm not compelling the deposition yet because I need to know when Colin Albert is available. And we have heard multiple different things from the attorneys for Colin Albert. From two different attorneys, we have heard two different things. And the court wanted more information about how Colin Albert would be available for a deposition, given that he is either at some type of a 3-week school before basic training or at basic training. We've heard both. So we'll see. The court also said that the scope of document discovery needed to narrow down. And in the court's order, the court specifically narrowed down the scope of that document discovery. It was broader in time than what Colin Albert's attorneys had asked for, but it was more narrow in scope than what Reed's attorneys had asked for.
On June 23rd, he received a call from a private Jordan Rosa in the Legal Service Department at Fort Jackson.
Why didn't you just file this?
He indicated he was returning a call to place last week. He made the request to Private Rosa about getting access to Mr. Albert, who, by the way, at this time, shortly after the hearing, he's now in basic training. So the 10-week basic training, the first 3 weeks was his initial school. He's past that. He's now basic training at Fort Jackson.
What we are learning now is that the information we got at the last hearing was that he was in basic training. But now we're hearing that at the last hearing, he wasn't in basic training. He was in whatever the 3-week school is before basic training. And now he's in basic training. But the last attorney at the last hearing said that he was in basic training. These seem to be two very distinct things. Why is the court not worried about this?
Private Rosa indicated that he was unaware of what process it would have. On June 26, 2026, Attorney Maddie received a call from Sergeant Lucas Vaughn at the Trial Defense Services in Fort Jackson. He indicated he asked about getting access to him from basic training for purpose of subpoena. He was told, quote, "That's not happening," is what the sergeant said. He said that the training regimen for basic training is very specific and condensed. He advised that eating and sleeping are the only breaks that the trainees receive. He said that following his graduation from basic training or advanced infantry training, which is what he's doing, he'll be a permanent party member at a duty station, and he's more likely to have access for a deposition at that time. On June 26th, Attorney Maddie received a correspondence from Colonel Jacqueline DeGain, basically suggesting that he would need the identity of Colin's commanding officer. We've now made several requests of Colonel DeGain for the identity of the commanding officer. Those have so far gone unanswered. So that's the current state now. We've had several calls with a private sergeant colonel. So far, don't have the information. It's been suggested to us that during basic training, they control their life from waking up to going to bed. That, like I said, the only breaks they get are sleeping and eating. And it's part of the turning.
I'm sure at some point they go to the bathroom, but right.
So that's the kind of information we have now. I believe he's in week 2 or 3 of basic training.
Okay, thank you. Attorney Seligson, is that news to you? Or have you had communications with...
I would think it's news to him, because he might not know, because we were preparing this to get...
Tuxbury, he's not talking to you. But listen to what Tuxbury's saying. I would think it would be news to them. This hearing's July 10th. What does that mean? That they did not distill this to writing, to email, or anything, and then disclose it to the other side.
Okay, thank you. Attorney Seligson, is that news to you? Or have you had communications with...
I would think it's news to him, because he might not know, because we were preparing this to get, and then we got the notice about coming today. So I kind of ran today. We had responded on the search terms. We did talk about search terms from Colin Albert.
Okay,
so we haven't had a chance to fill it in.
Why don't you reduce that to writing and let Attorney Seligson know so he can be prepared to make an informed...
How is that okay, though? These communications are from the end of June, and the court's like, have you turned this over to the other side? No. Okay, well, why don't you write it down and give it to the other side? Then why are we here for a hearing today?
So I kind of ran today. We had responded on the search terms. We did talk about search terms from Colin Albert.
Okay,
so we haven't had a chance to fill it in.
Why don't you reduce that to writing and let Attorney Seligson know so he can be prepared to make an informed response.
Thank you, Your Honor.
Just talking about it at this time.
That's right. I wasn't aware of that.
So the court doesn't want a response. He's like, write it down, give it to them so they can respond.
Response.
Thank you, Your Honor.
Just talking about it at this time.
That's right. I wasn't aware of the mechanics of where he is, but we are working productively on the search terms and narrowing the scope of the subpoena.
Okay.
So that's working productively.
All right. Attorney Tuxbury, you're welcome to stay, but on a Friday afternoon, you're welcome to leave, too.
I appreciate that, Your Honor. I think I'll take the invitation to depart. Enjoy the rest of your day, Your Honor. Thank you very much.
Thank you.
And that's the end. So where are we now on the motion to compel the deposition of Colin Albert? Well, they're going to have to continue this conversation later because the court told Colin Albert's attorneys, hey, everything you just told us, put that in writing, give it to the other side, and we'll figure it out. We're just discussing things today. Could have been an email? Yep, could have been an email. And the court's like, all right, we're done with this part. Thanks. We'll see you later. So the court's order, which essentially is not forcing Colin Albert to deposition or not, because the court wants more information, is still just waiting and just pushing this further down the road. And the attorneys said that they are working together on narrowing down the search terms, which the court has already ordered in some way. So I imagine there's not much more to do because the court said this is what the search terms are going to be. We are now moving on to plaintiff, the O'Keefe party's motion to compel further answers from Karen Reed. We have seen this motion run parallel to some of the other motions. This is the motion where the plaintiffs were like, this motion to compel needs to be heard. This is the same motion where Attorney Rose said, hey, if you had just included me on the email, we would have known that we hadn't responded and we can sort it out. At the last hearing, Karen Reed's attorney said we just turned over responsive information. I don't know if they've had a chance to look at it yet. So we're going to need to come back and see if there's anything else that needs to be finalized. But Attorney Rose had argued that he thought the motion to compel was moot because they had been turning it over. And the response from plaintiff's attorney was, we do not think it's moot and you didn't respond and now you need to respond. And Rose was like, okay, well, put me on the emails. I'm the one dealing with it. So let's see what the court has to say about plaintiff's motion to compel discovery or further discovery of Karen Reed.
And I've read everything. Mainly the issues relate to medical information and financial documents. And I guess I'll start with Attorney Seligson to ask you, given the, you know what the standard is, because your office has quoted it a number of times in the various your motions to compel, that parties may obtain discovery regarding any matter not privileged which is relevant to the subject matter involved in the pending action.
It's really broad.
Whether it relates to the claim or defense of the party seeking discovery or the claim or defense of any other attorney. Your opposition uses the term fishing expedition, which that's great if it's a criminal case, because that's where fishing expeditions are discouraged.
What?
Not allowed under Rule 17 under the criminal rules. But this is a civil case, and Rule 26 is very broad. So without getting into the specific...
I mean, the civil discovery rules are really broad, but there are still bounds to it.
Without getting into the specifics about the medical, why isn't merely the provisions of Rule 26 applicable here? And why shouldn't they require production of the information the plaintiffs request?
Your Honor, with respect to seeking her medical records for a 2-year period, even though the term fishing expedition generally applies in a criminal case.
I don't agree with that. I don't agree with that. I think the court thinks that, but I don't agree with the court's premise on that.
I don't understand why they would need to understand her health in 2020, 2021.
Yeah, that's too broad.
How about 2022?
That's different. Perhaps they, if they narrowed it, we could reach an agreement about something in confidence. But
did you have discussions about narrowing it? Did you two have discussions, or were you talking with someone else on these?
I spoke to Attorney Rosenberg.
Okay.
But
Right.
Hang on.
Because Rosenberg has been dealing with discovery. Right. Okay.
So the next issue relates to the financial documents. And there has been certain information provided. There's been certain information redacted. Have you had discussions about that?
we have had discussions, Judge. The redactions are for transactions that are not specifically asked for in the document request. So what we did was we produced the bank statements and credit card statements for the 2 dates that were asked. We blacked out and redacted account number and private information.
But somewhere you cited attorney-client privilege, I think, on that issue, which I had difficulty following.
So the court moved from medical information. And again, the request of Reed is going to be allowed to be broader than the request of Proctor in this case. Proctor is a third party in this case. Reed is a party. So there is going to be a difference there. Because of that, please keep that in mind. It's going to be different. We have skipped now from the medical question where Seligson was saying this span of time is too broad. We agree that during the relevant time, that might not be too broad. And the court just skipped right beyond that and said, okay, let's get to the medical and what's redacted. Seligson is saying, look, we provided what was asked for exactly for the dates that were requested. But if you have a bank statement and 2 dates have been asked for, your bank statement's going to have, 27-ish other days of records potentially? So it's perfectly fine to redact those because that's not responsive. They asked for 2 days. Just because they asked for 2 days doesn't mean they get the whole bank statement. You just redact out all the other days. Well, you didn't ask for that. It's not responsive. Here you go. You don't just give them more than they asked for. And now the court is asking about attorney-client privilege. Remember, if you redact something out or if you don't turn something over, you have to cite the privilege that you're claiming to not turn it over. And when we're talking about financial records, paying your lawyers would in fact be attorney-client privilege. So in bank records, that could absolutely happen. Let's see what they say.
Somewhere you cited attorney-client privilege, I think, on that issue, which I had difficulty following.
Attorney-client privilege? I don't believe we assert attorney-client privilege, Your Honor. If there is a payment to counsel, then that's what that would pertain to. And if that's reflected on the
Somehow I don't think counsel were getting paid by credit card at that time. Just a while.
Why not? Why wouldn't counsel be getting paid by credit card?
I don't have it in front of me with all transparency, but that would be the reason for it. The transactions that they asked for on the dates in question, we've given it to them. But just this broad wondering what else is out there and what else my client is spending her money on, it's not relevant, Judge.
I agree with that.
And she's entitled to some privacy on that front.
Right, but again, Rule 26 is so broad, it's not necessarily up to the party to say it's not relevant, because the standard is it might lead to the discovery of admissible evidence.
The court is saying that the discovery rules are really broad, which I agree, they are fairly broad. But Seligson is saying they asked for these documents regarding these 2 days. And so we turned over the documents with regard to 2 days, and the things we redacted are things they didn't ask for.
If they asked for transactions on January 28th and January 29th, and the statement covers January 1st to January 31st, we've redacted out things that aren't specifically asked for.
All right, well, so we'll give Attorney Diller a chance. Do you believe that?
And then anything outside of that window, the 28th and 29th, would be non-responsive.
There was information redacted on the 2 days in question that is relevant?
That's a good question. No, now the judge is using relevant. The word is responsive now, Your Honor.
Respectfully, I apologize. I don't have that redaction in front of me. I know that as it relates to anything on those 2 days, I believe there should be no redactions, and if things need to get filed that should be protected, we are amenable to redact.
It's your motion.
And if things need to get filed that should be protected, we are amenable
Oh, hang
to
on.
redacting those
Don't
out.
have it in front of you. I'm sure you have a copy there.
I don't have it in front of me either, Your Honor. It's his motion.
Facts.
My motion is the interrogatory is a separate question from a production of document.
So Seligson goes, it's his motion. And then Diller says, my motion is about the responses to interrogatories. Okay, but do the interrogatories ask for the documents? What are the interrogatories asking for if not the documents? So the court is the one that's asking about these areas of discovery. And Diller's like, that's not what my motion's about. Okay.
So in the interrogatory still remains unanswered. The production of document is a separate whole issue that we have an outstanding issue for production documents. I acknowledge that there was something that was turned over through production of documents relating to financial transactions. Our request asked them to articulate under oath, every one of the transactions that she had and the institutions that she.
So you're telling me that your interrogatory question was that Karen Reed identify all of her financial transactions in writing instead of just giving you the document? Because it sounds like they just gave you the document and they're like, here's the bank record. No. We wanted it under oath that those were your bank records.
Our request asked them to articulate under oath, every one of the transactions that she had and the institutions that she filed them for those 2 days so that we can track both her whereabouts and also whether it's reasonably calculated, lead to discovery of admissible evidence, which is significant for just a 2-day period of time.
Okay.
Response to that, Your Honor, as we are entitled to under the rules, we are entitled to say, here are the documents that answer your question with appropriate redactions.
So Diller is saying, and Diller is plaintiff's counsel, O'Keefe parties, said, we've asked for Karen Reed to answer our question under oath, which is interrogatory, sworn, about financial transactions for these 2 days periods. And Seligson is saying, right. So we gave you the financial records for that 2-day period.
Let's go back to the medical issue for a second.
Why?
Doesn't sound like the two of you have
Are we done with this? No? Okay.
spoken about the medical issues. And you suggested there might be a limited period of time that there could be some agreement on. So I'm going to ask counsel to go talk about it. And I'm going to ask counsel to keep in mind the reference by Mr. Diller to the testimony from the criminal case and the forensic scientist relative to medications. Cited on page, it's in their reply, I think.
Any medications Karen Reed was taking in like the day or two before this, the day of this, would be relevant.
Page 2 of the reply, Your Honor.
So I'm going to give you a little time to go talk about that. And hopefully you'd also take the time to talk about the other financial records. All right? If you can't do it, you come back, I'll hear you, and I'll issue a decision at some point.
Somebody's phone's going off in court. It's not ours.
Okay?
Okay.
Thank you, Your Honor.
Great. Thank you.
So on plaintiff, the O'Keefe party's motion to compel further responses from Karen Reed, the court asked them about financial documents, medical documents, and if they could narrow it down, and then said that the attorneys go talk about it and figure it out. And then if more information is needed, the court will then take it up. Let's see what happens, because the court's sending them out to go talk about it. Go talk with each other.
What are the parties asking me to do relative to the motion to compel?
Your Honor, as stated at sidebar, the parties have reached an agreement. We're asking you to table the current motion, for instance, interrogatories for a later date. We'll try to have that all resolved timely.
Okay, court will take no action. Thanks for coming down.
So they went to sidebar before they went back on the record, and they're going to keep working on it. So they put a pin in it. The problem, as I see it, from what we have witnessed in this case, is that the attorneys on all sides have lost the ability to just navigate these things with one another. The court told the attorneys to navigate these things with one another, and then if they could not be resolved, bring them to the court. And it feels like parties are just unwilling to genuinely communicate with each other until they're before the court. And the court's like, go talk. And they're like, okay, it's resolved. Why couldn't you have done that before? But when the court says go talk, now all of a sudden it can be resolved. If it could be resolved without court action, it could have been resolved over the phone, in my opinion. But no, things keep coming to the court. And with the motion to compel further responses, it's just getting tabled. And what's going on, Emily, with the motion to compel Colin Albert's deposition? Well, the court's put a pin in it, and they will circle back at a later date because the parties had the information at the end of June ahead of the July 10th hearing date, but did not provide it to the other side. So Colin Albert's attorneys did not communicate that information to Karen Reed's attorneys in advance of the hearing. So they got to the hearing, the attorneys got new information for the first time, and then the court said, well, now you need time to respond. So what was achieved in court? It seems that the motion to compel further responses from Karen Reed has been resolved, and more information is still needed regarding Colin Albert. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerd.app.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.